Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, we are coming to you from our beautiful Central Washington location right here in Cle Elum, Washington. But that's the only thing that's beautiful today, because unfortunately we got some bad news, and it deals with the matter of Hartford v. Ferguson, which is a challenge to House Bill 1240, better known as Washington's assault weapon ban, which was filed in the Western District of Washington, the United States District Court. There was a motion for a preliminary injunction. The court has ruled, and you're not going to like the ruling, and you're really not going to like the reasoning. So today, let's spend a few minutes and get you up to speed on U.S. District Court denies the injunction on Washington's assault weapon ban case. Hey, before we get going down the road we're going down, proud to announce that this video is being brought to you by Guardian Arms. That's right, Moses Lake's best and premier FFL is located right here in Moses Lake. Now, in addition to being an FFL manufacturer and doing standard sales, they're doing custom Cerakoting, gunsmithing. Listen, they got all kinds of cool things around here, and you should definitely check out their YouTube channel, which is Guardian Arms Training. So the next time you're in Moses Lake, stop on by and see my good friends right here at Guardian Arms. Okay, so the case we're talking about, ruling came out earlier today. I've had a chance to get through the order a couple of times. I will get through it a little bit more and probably do a more thorough video when I get back over to the main office. However, the case is Hartford v. Ferguson. The ruling came out earlier today. It is Tuesday, June 6th, D-Day. And I've had an opportunity to get through that order. I want to kind of share with you, but at the end of the day, the court has denied the injunction. Now, let's remember that in order to get an injunction, you must show two things. Number one, irreparable harm. That is, if this law is allowed to be enforced, I'm going to suffer harm such that I can never be made whole again. Court had said, no, we don't see the irreparable harm here. The second thing is the court also has to find that you are likely to prevail on the merits. The court has found that the Hartford plaintiffs here are not likely to prevail on the merits. Now, that's not the most frustrating part about it. The most frustrating part about it is the judge who issued the ruling here clearly has not kept up to speed with current case law, because we're going to see time and time again in this order this two-part balancing test where we're going to balance the societal needs against the individual liberties. The problem is that two-part balancing test was soundly rejected and thrown out on its ear a year ago in the case of New York Pistol and Rifle Association v. Bruin. Speaking of Bruin, obviously the two cases that if you're trying to uphold this law are going to get in the way are, of course, the Bruin opinion and District of Columbia v. Heller. So what did the court do? Well, the court started out right away undermining both Heller and Bruin as follows. The plaintiffs misread Heller and Bruin. Heller noted that the right to keep and bear arms protected under the Second Amendment is limited to the sorts of weapons in common use at the time. It found that this limitation is supported by a historical tradition of prohibiting dangerous and unusual weapons. Heller does not hold that access to all weapons in common use are automatically entitled to Second Amendment protection without limitation. Further, under Bruin, if plaintiffs demonstrate that their proposed conduct, that of buying and selling weapons regulated by House Bill 1240, is covered by the Second Amendment, the Constitution presumptively protects that conduct. This presumption can be overcome. So yes, that is right. This court has found that semi-automatic rifles and all the sorts of weapons, which are now banned by House Bill 1240, are not in common use. Now, this despite the fact that the ATF has already referred to the AR-15 as the most commonly used modern sporting rifle for all sorts of legitimate and lawful purposes. But hey, why let the facts get in the way of where you want to go? Now, after finding that there is insufficient evidence to prove that these types of firearms are in common use, the court then went on to acknowledge that under Bruin, there needs to be some sort of a historical analog to justify any type of regulation. And of course, they were able to find these analogs in regulations of Bowie knives, multi-shot revolvers, and of course the Tommy gun. And so you got to understand what the court's theory is, and this is a very novel theory, is that when weapons are initially developed for the military, and then there's a civilian application of them, and they move into the civilian market, that just because they become common use firearms in the civilian market does not afford them the protections of the common use doctrine. And despite the fact that the Heller court makes it very clear that the only types of weapons that we can ban are weapons which are both dangerous and unusual, the court here carved out a new rule of law, which is exceptionally dangerous weapons. And as you can see from the following paragraph, for whatever reason, decided to employ the two-part balancing test, despite the fact that the United States Supreme Court has soundly rejected it. The court ruled as follows. House Bill 1240's proponents have shown that unprecedented social concerns have risen from the proliferation of these weapons. These weapons are exceptionally dangerous. Assault weapons are used disproportionately in mass shootings, police killings, and gang activity. And just to make sure that the court relied on the now defunct, now overturned two-part balancing test, the court concluded its reasoning as follows. The burden imposed by both the historical regulations and House Bill 1240 are relevantly similar. They impose comparable burdens on the right of armed self-defense, and those burdens are comparably justified. The burden of House Bill 1240 on armed self-defense is slight. The proponents of House Bill 1240 have pointed to evidence that assault weapons are rarely used for self-defense. Moreover, the burdens imposed by the historical regulations listed above and House Bill 1240 are comparably justified. All were enacted in response to public safety concerns regarding weapons considered to be extremely dangerous. So that is how they essentially just worked their way all the way around the Heller opinion to make sure that that does not apply. Now, in regards to irreparable harm, is there going to be any sort of irreparable harm? We basically see the argument of, hey, listen, you don't need assault weapons for self-defense. And what the court basically said, and I'll summarize it here, is just because you can't get an assault weapon doesn't mean you can't get any other kind of firearm. You can still defend yourself, so quit your complaining. Now, like I said, we'll be doing another video. We'll break down and dissect this case a little bit more once we have a chance to do a better autopsy on it. Obviously, this does not bode well for the overall likelihood of success as it relates in this trial court. Now, understand that even if you lose, we know that these cases are going to be ricocheting around. But if you're keeping score right now, we got one case in state court. That's Guardian Arms versus Inslee. But that case got punted from Grant County to Thurston County. Not good. We got two cases in federal court, okay? We got Hartford v. Ferguson in the Western District of Washington. We had these developments today. Not good. And then, of course, we have Banta v. Ferguson over in the Eastern District of Washington. But that is before the same judge who was supposed to issue the injunction on the magazine capacity back in December of last year. So I guess we kind of know where to put the smart money. Obviously, these things are a long way from over. There's a lot of other issues. We realize that between what's going on here, what's going on in California, in the Ninth Circuit, what's happening in New York, and especially what's happening in Illinois, that this issue absolutely positively is going to be stampeded up to the United States Supreme Court in the very near future. Listen, you may have more questions about what's going on in Hartford v. Ferguson, anything else related to House Bill 1240, or anything else related to what's left of your Second Amendment rights. You guys should know how to contact Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.